Welcome back to Three Simple Things, a Gennari Aronson series of tips and information from our corporate and transactional practice. Today's topic is independence of outside directors. One of the best defenses to problematic claims from aggressive and disgruntled stockholders is to show that transactions, particularly transactions with controlling stockholders, have been approved by a committee of the board composed of independent directors. Independence is required for public companies by both the SEC for audit committee matters and for companies generally by the New York Stock Exchange and NASDAQ, which require that a majority of directors serving on the board qualify as independent. In civil litigation, state courts, and particularly the Delaware courts, which generally hear most of the business litigation in this country, have issued much more stringent requirements as to what constitutes an independent director. While this is an evolving area of law, recent decisions might surprise you as to what makes a director who thought he or she was independent not independent and lose their independence status. The takeaway is that outside directors need to closely monitor their independence and understand that the term can mean different things for different purposes. To ensure your ability to exercise independent judgment and reduce the chance of ending up in court, or even worse, losing in court, be sensitive to both personal conflicts of interest and relationships and actions, whether recent or long term, that could be deemed to create divided loyalties. There are three typical scenarios in which a director is deemed not to be independent. First, there is a familiar relationship between the controlling stockholder and the director. For example, Ms. Jones, who owns 80% of the company, may want to name her niece, who teaches at Harvard Business School, as a director. Regardless of whether her niece is a business savant or not, her family relationship will almost automatically disqualify the niece as being deemed an independent director. The second scenario is where there exists a direct, significant financial or other business relationship between the outside director's business and the company where he or she serves as a director. A major vendor may be a great director because of his or her knowledge of the company's business, but this financial relationship with the company causes the once independent director to be deemed not independent. Finally, an outside director may be deemed to lose independent status where another relationship exists between the control stockholder and the independent director, such as a personal or civic relationship. For example, courts have allowed suits to go forward where plaintiffs' alleged directors were not independent for a number of reasons. Here are just a few examples. The first situation is where the independent director was named to other unrelated corporate boards by the CEO, chair, controlling shareholder, or financial sponsor. A second situation is where the independent director served on the board of a college alongside the interested party who was a major donor to the school. A third example is where partners in a venture capital firm who served on the board of directors of a company invested in sectors where the company made acquisitions. Two other situations. Directors may be deemed not to be independent where they share investments or personal assets, such as a private jet, with the CEO, chair, or controlling shareholder. Finally, in one of the more interesting decisions, the court ruled that a director may be deemed not to be independent where the outside director received token benefits from an interested party, such as a private museum tour for relatives, while a transaction that was under consideration was taking place at the company. In this area of determining board independence, perception may be as important as reality, as courts often will not dismiss a case at the early stages of litigation and could impose a more exacting level of review, sometimes referred to as the entire fairness doctrine, even when the independent director has the corporation's stockholders' best interests at heart. As always, this is just a brief overview, and we strongly recommend that you consult with your legal advisors before taking any action.